Good morning, everyone. My name is Aline Shormoff, and I'm the Senior Vice President of Community Development and Engagement at the Federal Reserve Bank of Minneapolis. And I'm pleased to welcome you all to our virtual convening about the intersection of research and practice on non-compete contracts. We thought it was important to convene this discussion and to share our research on the use and impacts of non-compete contracts because of the effects those contracts can have on low and middle income workers. We found that a surprising number of low and middle income workers have non-competes, and other research has linked their non-competes with lower wages and a variety of other labor market effects. Understanding these labor market effects, or how non-competes affect workers, is a critical part of the Federal Reserve's mandate to support maximum employment. If you're here, you probably know what a non-compete contract is. But to be clear, we define them as contracts between employers and employees that limit an employee's ability to start a new business or a new job. Other related employment contracts may also be part of this discussion, but non-competes are really the main focus. This morning, you'll first hear about findings from brand new Federal Reserve survey data on non-competes. And in addition to using survey data to better understand how workers are impacted, you'll hear insights from individual worker interviews that focused on how these workers experienced having a non-compete. After, we'll hear from a panel of subject matter experts from Illinois and Colorado and learn about recent changes in those states' non-compete rules. Getting this insight is especially timely here in Minnesota, where the state recently became the fourth in the nation to make non-competes broadly unenforceable. With recent action from the Federal Trade Commission and the National Labor Relations Board on this issue, there's clearly national interest as well. So I'm excited to be kicking off this important conversation. Thank you all for joining us. And now I'm pleased to introduce Tyler Besch and Mary Hogan for their presentation.
Thank you, Aline, and thank you to everyone for joining our event today. My name is Tyler Besch, and I'm joined by my colleague, Mary Hogan, and we are both part of the Community Development and Engagement team here at the Federal Reserve Bank of Minneapolis. We're really excited to present some new findings about non-compete agreements from a few projects that we've been working on. Before diving into those results, I just want to provide a quick disclaimer that the views expressed here are the presenters and not necessarily those of the Federal Reserve Bank of Minneapolis or the Federal Reserve System. So to begin, I just want to talk a little bit about non-compete research, the landscape of that research, and the data sources that we have been able to use in the past. One challenge with non-compete research has been a lack of data, but there are two key exceptions that we've benefited from. Firstly is a survey fielded by Starr, Prescott, and Bashara back in 2014. And this was a one-time survey that really provided us with some of the first estimates of non-compete prevalence in the United States. A second exception is a recent round of the National Longitudinal Survey of Youth, specifically the 1997 cohort. And this is a small but rich longitudinal survey that asked respondents whether they have a non-compete agreement with their employer. So for this small cohort of individuals, we were able to have nationally representative data of the prevalence of non-compete agreements. But due to this general lack of data, the most recent round of the Survey of Household Economics and Decision-Making is a very welcome addition to the non-compete data landscape. For the last 10 years, the Federal Reserve Board has conducted the Survey of Household Economics and Decision-Making, otherwise known as the SHED. And the SHED measures the economic well-being of American households, and it identifies potential risks to their finances. It does this by asking a range of questions around a number of topics, including things like credit access, retirement, and even things like student loans. It also benefits from being a relatively large sample. Last year, the sample size was right around 12,000, and that was the case for this year as well. And so as a result, we now have the first nationally representative data of the US adult population with information on non-competes. My colleague Ryan Nunn, along with colleagues at the board, Mike Zabek and Jacob Lockwood, and myself, took a deep dive into this new data, and we looked at the prevalence of non-compete holding along a wide range of characteristics, as well as how non-competes relate to things like financial insecurity and instability. All of those findings are included in a new article recently published on the Minneapolis Fed website, and I wanted to highlight some of those findings here. Firstly, I wanted to speak a little bit to the geographic variation of non-compete prevalence in the United States. So what you're seeing here is a map grouped by census region, where a lighter shade indicates a smaller share of workers reporting that they have a non-compete agreement, and a darker shade indicating that there is a larger share of workers with a non-compete agreement. We see that on the West Coast in states like California, Oregon, and Washington, that there is the lowest prevalence of non-compete agreements, hovering right around 9%. Meanwhile, on the southeastern portion of the United States, in states like Florida and the Carolinas, we see the highest prevalence of non-competes. So it's hovering right around 13.5%. I think there's really two important takeaways from this figure. Firstly, just that there's a lot of geographic heterogeneity when we look at the landscape of the United States. You know, it's not one story for our whole country as far as where non-competes are more or less prevalent. And secondly, there's an interesting correlation between the geographic variation of non-competes and its enforceability. Specifically on the West Coast, California has banned non-competes, and Washington and Oregon have banned non-competes below a certain income threshold. So it's interesting that we see this association between prevalence and enforceability. I think it's important to highlight as well that we can't say this is a causal relationship just based on this figure, but it's an interesting relationship that we might expect, and it's certainly something that warrants further research. Another really interesting aspect of the most recent round of the SHED is that it now allows us to look at the prevalence of non-competes across a wide range of demographic characteristics. And I think one of the really interesting demographic characteristics is age and how non-compete prevalence changes over the age profile. When we looked at the data, we found that non-compete prevalence increases as workers reach kind of those middle career ages, looking at the 35 to 44 age bin. And that's where we see non-compete prevalence peaking right around 13.5%. We see, again, that increase right into that peak, and then the prevalence decreases pretty consistently as workers reach retirement age. So we see the lowest prevalence as workers are in the 65 to 74 age bin, and the lowest in that 75 plus age bin, where we see very few workers reporting that they have a non-compete agreement. Another interesting takeaway from this figure, I think, is that it nicely corroborates some other findings from previous data sources. So you might recall that I mentioned the National Longitudinal Survey of Youth also asks about non-competes. And when we look at the same age profile in the SHED, we find that the non-compete prevalence is very similar to that in the National Longitudinal Survey of Youth. So when we're looking at a topic that has relatively small amounts of data available, it's always encouraging when we see two data sets corroborating each other. The final relationship that we wanted to speak to is the relationship between non-compete holding and financial resilience. Non-compete holders are subject to their non-competes if they leave their job, but also if they are laid off or even fired from that job. And due to the geographic time constraints of a non-compete, this could make it more difficult than it otherwise would be to regain comparable employment. So we might think that workers having a non-compete could be less financially resilient than those without non-competes. In order to better understand this relationship, we took a look at the relatively well-known $400 question that the SHED asks. And specifically, it asks, if you were faced with a $400 emergency expense, would you pay for that expense with cash or with a credit card that you would pay in full in your next statement? And so what we do initially, if you look at the leftmost bar where it's labeled unadjusted, we look at the share of workers with a non-compete that say they would pay for that emergency expense. And we compare it to the share of workers without a non-compete that say that they would pay for that emergency expense with cash. And when we do that, we find that the non-compete holders actually are 5.5 percentage points more likely to pay for that emergency expense with cash. But we know that this comparison is a little bit fraught because on average, non-compete holders are quite a bit different from those without non-competes. For example, we know that on average, non-compete holders tend to be in higher income brackets. They tend to be in different types of occupations than those without non-competes. And they also tend to be in different industries. Those are just a few examples. So what we do is we adjust for some of these characteristics to make sure that we are comparing similar non-compete holders to those without non-competes. If you look at the next bar, we first adjust for age, education, and gender. And when we do that, the difference between non-compete holders and those without non-competes essentially disappears, such that both groups are relatively as likely as the other to pay for the emergency expense with cash. And then when we add further controls, so we're adjusting for age, education, and gender, plus rural status, occupation, industry, and state, we see that the relationship actually flips such that non-compete holders are about 4.5 percentage points less likely to pay for that $400 emergency expense with cash. Now, again, as it is for all of the other figures, we want to make clear that this is not a causal relationship of non-compete holding and financial resilience. But again, this is another important piece of evidence that we're able to see now in the SHED survey, and it's something that certainly warrants further research to understand that relationship. So with that, I want to pass it over to my colleague, Mary Hogan, who's going to speak to some of her compelling findings from her qualitative research on non-compete holders.
Thanks, Tyler. As Aline mentioned in her opening remarks, a key part of our mission here in the Community Development and Engagement Division at the Minneapolis Fed is to use our policy analysis and our research to better understand how policies are impacting low and middle income groups of people here in the 9th District. In the case of non-competes, as you just heard Tyler present, our research team has done a great job looking at the quantitative data and shedding light on the broad themes that we're seeing related to non-competes and workers. But that data doesn't tell us the full story. It doesn't tell us who these workers are. It doesn't tell us what their experiences are. And as we asked these questions, it became more clear that we really needed to talk with workers to better understand their experiences and to better understand non-compete policies in general. So that's what we did. Over the course of the last several months, I, along with some of my colleagues, have conducted qualitative interviews with workers here in the Twin Cities who either currently have a non-compete or had one with a recent position. These workers came from a variety of backgrounds, including cosmetology, logistics, transportation, printing, healthcare. And while all of their experiences were unique, there were 3 themes that emerged that I consistently heard from my conversations with these workers. And that's what I'd like to share with you all today. Next slide, please. So the first theme that emerged was related to the timing of signing the non-compete. Several workers that I spoke to relayed experiences of the employer presenting the non-compete in the final stages of the hiring process. This might be after they already submitted their notice to their previous employer, or it just might be as they're signing all the final paperwork and they don't feel that they have the ability to negotiate or say no to signing the non-compete. In fact, one of the workers that I spoke to said, my hands were tied at that point. Do I want to work or be unemployed? You sign it and you keep going. And this piece about with the timing is consistent with previous research that's been done in the field related to non-competes and late timing. Another piece that came up was that a lot of workers didn't fully understand what they were signing, and that the employer didn't necessarily encourage them to spend more time with the document or to take the document home to consult with family or to consult with an attorney. One worker I spoke to said, not a lot of hairstylists have an education beyond high school, and you're looking at legal documents and there's no way for us to understand. At that point, I didn't get it. Next slide, please. The next theme that emerged was related to the broad scope of non-competes. And there were two workers in particular who had extremely broad contracts. The first was a cosmetologist who, under the confines of her non-compete, she was banned from cutting hair within 25 miles of the salon's 4 locations of her previous employer. And that ban essentially banned her from cutting hair in the entire Twin Cities area. And this was, a practice that that was where she had received her training, that was her career, and essentially she was banned from practicing in her field and in her entire geographic area. Another worker that I spoke to was banned from working for a competing employer in the lower 48 states for 2 years. Now, in Minnesota, we've historically had what's called the blue pencil doctrine, which enables a judge to amend a contract if it's deemed to be too onerous for the worker. And so it's questionable about whether these contracts would have withstood judicial scrutiny had they been before a judge. But in the case of these workers and in other workers I spoke to, they didn't necessarily know what their rights were or didn't feel that they had the financial resources needed to bring the case to court. So as a result, these broad contracts that may not have withstood judicial scrutiny still affected those workers. The next slide is related to the workers' experiences with non-competes, both the immediate and the long-term experiences that they had with those. In the immediate, I heard a great deal about immediate feelings of stress and anxiety with the non-compete. Specifically, I heard a lot about there was uncertainty about adhering to the non-compete and questions about who a competitor for your employer was. In particular, one worker I spoke to who worked in logistics said, logistics is such a broad industry. Who is your competitor? He worried that he would take a position with another company that he didn't necessarily understand to be a competitor with his previous employer, but that they might, and as such, he might put himself at risk of being in violation of the non-compete. In terms of the long term, I heard a lot about long-term impacts to financial stability. One worker in particular I spoke to, he was laid off from his position, but he was still subject to the terms of his non-compete with his previous employer. And as he was looking for jobs that met the criteria that he was bound by with the non-compete, those jobs paid significantly less than what he was making at his previous employer. As such, he feels that really impacted his long-term financial future. He said, if the non-compete was not there, I'm confident that I would be near what I was making. The non-compete took away my options and my opportunities. And one final example, in the case of cosmetologists, when they would move their practice outside the geographic scope of that the non-compete required, they would have to rebuild their client lists, something that takes a lot of time and relationship building, as you can imagine. And with the workers that I spoke to, it had been sometimes 2-3 years since they left their previous employer, but they had not yet rebuilt their client lists. And that had impacts to their financial security. One person I spoke to said, I would love to have just one job, but it's just not possible. And in closing, I just want to say, these themes that emerged from the interviews highlighted all the different impacts that non-competes can have on workers. As policies shift on this issue, it will be important for us to continue to check in about how workers are faring with these contracts. And next slide, please, Tyler. And with that, I would say that if you are interested in continuing to follow our work here on non-competes, I would encourage you to check out the website, the Minneapolis Fed website, or if you have questions about what you heard today from my qualitative research or my colleagues' quantitative research, our contact information is listed there. And with that, I'm going to turn it over to my colleague, Ryan, for the next part of our event. Thank you.
Thank you very much, Mary. I think that's going to be great framing for the conversation that we're going to have. And thank you all for joining us for this conversation. My name is Ryan Nunn. I'm Assistant Vice President for Applied Research here in Community Development at the Federal Reserve Bank of Minneapolis. I've worked on a variety of economic policy issues, including non-competes for a while now. Like my colleagues, my views are mine alone and not necessarily those of anyone else in the Federal Reserve System. Our group in community development at the Minneapolis Fed focuses on a few particular areas, one of which is research on labor market practices and policies, including non-compete contracts. So for us, this is an important conversation. And we're here really this morning to talk about policy changes at the state and federal levels that matter for workers, for businesses, and for the overall labor market. There's really been so much activity, even just in recent weeks, that I'm really excited about this conversation. I think it's very timely, and I personally expect to learn quite a bit. Having just heard from my colleagues about the roles that non-competes play in workers' lives, what I want to do in this conversation now is get into the weeds of how the policy details matter. And those policies, as many of you know, have changed in really substantial ways across the country, with Colorado in 2022, Illinois both in 2017 and in 2022, Minnesota, just in a couple weeks, and a couple days ago, learning that New York State is joining that list. So as I said, a lot of activity. And I want to learn from our panelists about what went into the deliberations around changes in the conversations that they were part of. What, if anything, we know about preliminary effects of those changes, how the state level changes interact with ongoing federal efforts, and then what would be useful to know from researchers, including some of the folks I think are in the audience. And we'll see if we get to all of that in the course of the discussion. Along the way, we'll also talk about other contracts that are often bundled with non-competes, other restrictive covenants. And really importantly, we want to get to questions that you have for us. So, please do remember to type your questions into the Q&A, and I will do my best to kind of weave them into the conversation. And I think we're really fortunate to have just a fantastic panel to address all of these questions. So I'm going to give just really brief introductions, but then direct you to our website where there's more on each of our panelists. So I'll start with Jane Flanagan, who's director of the Illinois Department of Labor, Jeff Glass, partner at the law firm Amundsen Davis, and David Seligman, executive director of the nonprofit legal organization Towards Justice. All of our panelists have been involved in public discussions of non-competes in various ways that I think make for a really rich conversation. And again, you can find more about their bios on our website. I mentioned a moment ago that we would love to take your questions. I know we have a lot of folks in this audience who have deep expertise in this area, and so we would really love for you to feel free to put those questions into the Q&A. And so with that, I want to just jump right in, and I'm going to start with you, Jane, and ask you about the recent amendments in Illinois to its Freedom to Work Act that substantially changed how non-compete contracts are enforced. Can you describe the change, and then please tell us, what that experience has been like? Has the state run into anything unexpected?
Sure. So thank you, Ryan, and it's a pleasure to be here and hearing about this really interesting and important research, as well as having this conversation with my distinguished panelists. So thank you for having me. My views are also my own and don't necessarily represent my employer, the state of Illinois. In regards to the Freedom to Work Act, this act was passed in 2017. Originally, it was a pretty limited, straightforward income threshold that basically said non-competes were unenforceable for what was essentially minimum wage workers earning under, I think it was $13 an hour or something like that. It was then significantly amended in 2021. As you mentioned, those changes took effect in January of 2022. It significantly increased that income threshold, making non-competes unenforceable for workers earning under $75,000 a year annualized. It also touched non-solicits for workers earning under $45,000 a year. The changes also kind of incorporated some of the traditional common law standards around what makes a non-compete enforceable above those income thresholds, right? So what are the factors that a judge would review, or and took some of those definitions in as well. It added Attorney General enforcement. So a worker can complain to the Attorney General and there is an enforcement procedure. Importantly, and I had previously worked at the Attorney General's office. I had been doing those investigations pursuant to common law, but it sort of formalized that power. Importantly, it did only impact non-competes entered into after the effective date of the law. So in talking to my former colleagues, for example, at the Attorney General's office, one of the things they've said is that it hasn't been this flood of complaints, right? I think in part because many workers who are covered by non-competes are covered by non-competes that were entered into prior to January 2022. So I think that it will take some time to understand the impact of this law, because many of those folks who are working under non-competes right now couldn't essentially complain under the new standards. And then there's always, I think, this question of there's the law in the books, and then there's what workers know about. And I think this speaks to some of the research that was just discussed as well, right? Workers may not know that they're entering into a non-compete, and they may not know on the other end that there are forums for them to challenge that non-compete or how they would do that. So I think those are kind of factors that we're seeing play out in Illinois now.
Thanks, Jane. I've been thinking about that issue you referenced about the lack of retroactivity as something that matters for researchers who are trying to estimate the effects. This is something that for reforms like the one Minnesota just enacted will also just play out slowly as they apply to new non-competes. But I'd like to turn now to Jeff. You've worked with employers in Illinois and throughout the region on issues related to restrictive covenants, and I'm really interested in what their and your experience has been of Illinois' reform.
Sure, yeah, and thanks again for inviting me to participate. It's quite an honor. What I'm seeing so far, Jane's right. The law only impacts agreements entered into after January 1, 2022. So we're still kind of seeing how it's shaking out. I would make one clarification maybe on what a non-compete clause is. A non-compete clause bans an employee from working usually in a geographic area in a certain industry for a certain period of time. And it should be distinguished from a non-solicitation provision, which bars the employee from going after the customers that he or she worked with for the former employer. So the non-compete is a lot more burdensome than a non-solicit. I just want to clarify that, for the discussion's sake. In terms of what I'm seeing is a couple of things. First of all, there's a 14-day notice provision now under Illinois law. So an employer has to give an employee 14 days prior to starting work and tell them we want you to go have your own attorney review this. And you have to give them 14 days either before the start of work, or if you give them to them on the first day of work, they have 14 days before they have to sign it. they can waive that if they want, but that you have to specifically inform the employee to go talk to their own lawyer. I think that helps the employees who might not understand, although undoubtedly some people are just going to sign it anyway or not go see an attorney. But and then the other thing is that there's a fee shifting provision now in the Illinois Freedom to Work Act. So typically, I know my clients, we'd have a one-way fee shifting provision in our agreements where the employer would get their fees if they won in any litigation to enforce the agreement. Now that goes both ways. So we tell our clients, if they're considering litigation, all right, you can go after them, but if you lose, you're going to have to pay their attorney's fees. And that does have an impact because some of these cases would get decided because the employee didn't want to face the prospect of paying the fees, and they might get fired or they might not take the job. So now that has definitely leveled the playing field. I think that's a significant one. Those two, the notice provision and the attorney fee shifting already and how my clients are acting. And then the income thresholds are significant too. You have to make $45,000 to have a non-solicit, $75,000 for a non-compete. The non-compete goes up $5,000 every 5 years, I think, and the non-solicit goes up $2,500 every 5 years. So most people do meet those income thresholds that I'm seeing, but in terms of the impact, that's what I'm seeing so far, and we're just staying tuned to see, as the cases wind through the courts, what happens.
Thank you, and I know we're going to return to many of the points that you raised here in the conversation. So turning now to you, David, we've talked a lot about Illinois upfront, but Colorado, where you're based, also implemented a recent non-compete reform, and I was hoping you could tell us a little bit about the concerns, the motivations that led to those changes and their specific features.
Thanks so much, Ryan, and thanks for the invitation. It's really a pleasure to serve to be on this panel and participate in the conversation. So Colorado, for decades and decades and decades, had always sort of prided itself on prohibiting non-compete agreements, right? Part of this like Western libertarian sensibility. But because our statutes and case law had included really broad and vague exceptions to our prohibition against non-compete agreements, we saw that in practice, the purported prohibition meant very little to workers up and down the wage scale. And so, and as a consequence of that, we saw lots and lots of non-compete agreements with workers who, frankly, many of whom were making just barely above minimum wage. And in many, many cases, we saw non-compete agreements that, from my perspective, no court would ever enforce, going back to James' point, but that workers were way too fearful to ever, affirmatively challenge, and didn't really have the tools to affirmatively challenge because of weak enforcement mechanisms, because of blue pencil standards, and the ability by employers to request that courts narrow non-compete agreements. There was very little incentive, frankly, on drafters not to overreach, right? And in fact, we saw lots and lots of overreach. That included, we also saw lots of, and I think this is a trend around the country, which could be the subject of a whole different panel, lots of what we think of and what the FTC has termed as de facto non-compete agreements, restraints that operate like non-compete agreements. Two variations of that I want to highlight. First is what we sometimes call stay or pay contracts that require workers to pay substantial sums of money if they leave their job, including training repayment agreement provisions, and also no hire and no poach agreements that operate like non-competes, especially in the context of what some people would call the fissured workplace, right? Where there's, the labor market intermediaries and where a worker may have maybe performing work directly for one employer, but where that employer has a lot of contractual relationships with lots of other employers. So the 2022 reforms in Colorado sought to clarify and strengthen the law. We got rid of an exception for management employees, which had been quite broadly construed as an exception that effectively swallowed the prohibition generally, and narrowed an exception for any non-compete that was for the protection of trade secrets. So now in Colorado, non-competes are broadly unenforceable for any worker who makes below what the Colorado Department of Labor's threshold for highly compensated employees. In 2023, that's $112,000. We, even for workers making above those amounts, the law now requires that the non-compete be reasonably necessary for the protection of trade secrets. There are some additional exceptions that from our perspective, prove the breadth of the prohibition, right? So narrow exceptions for certain forms of employer-driven debt. So training repayment agreement provisions that require workers to pay back the cost of training are allowable, but only in certain circumstances, only where the costs of the training are reasonable and the purported costs are tied to the actual costs that's borne by the employer, and where the shifting those costs onto workers wouldn't result in a violation of wage and hour law, because the training is primarily for the benefit of the employer and not for the benefit of the employee. Additionally, it includes substantially strengthened enforcement mechanisms. So now the law allows for affirmative private litigation by workers to recover their actual damages as a result of wage suppression or other actual harm, and in addition to that, $5,000 in statutory damages if they're subject to an agreement that violates the broad prohibition. Additionally, the Attorney General has enforcement authority. The law also explicitly provides that Colorado law applies, the prohibition applies to workers employed in the state, regardless of any choice of law provision in contracts. It's sort of yet to be seen how employers are going to respond. But one change we have seen is we have seen employers now sensitive to the applicability of this statute to training repayment agreement provisions, which I think is something that was not familiar to them before. So again, I'm not part of the conversations that these employers are obviously having with their counsel, but we have seen in the case of one employer, a very prominent Colorado employer who had maintained a training repayment agreement provision. They dropped it when the law became effective in August 2022. So some promising developments, but and we hope to see more of that. I mean, the law is designed to deter drafter overreach, but still not much case law interpreting it.
Thank you. There's also quite a bit here that we'll definitely want to return to, including in particular questions of how some of these reforms can or are going to be enforced. I think that's something I hadn't thought so much coming into this that I want to talk about, but I hope we can get back to. There are also great questions coming in from the audience, but I want to ask one more of mine just to kind of frame up some of the conversation, turning actually to Jeff now again. I was hoping you could kind of help us back up for a moment and get a better understanding of what's at stake from an employer perspective. So, what are the key reasons that at least some businesses consider non-competes to be useful? I think that's a helpful place to start for a lot of this conversation.
Sure, and this applies to non-solicits as well. There's three main things. First of all, there's information and relationships, okay? So your customer relationships, if you got a long-term customer, you bring in a sales rep, you introduce them to the customer, you pay for him or her to entertain them, you pay for their car and their phone, you pay them the salary. It's a repeat business type of account. When that sales rep leaves, the employer wants to have a reasonable opportunity to keep that in-house. And under the law of most states, if they can show that the employer supported the development of that relationship, and if the restriction is reasonable, it's not overreaching. For instance, if you say, I need 18 months to keep this in-house, transition to a new sales rep, because the buying cycle is like every year, you can justify the restriction. That's one reason an employer wants a non-compete or a non-solicit, to keep the relationships give them a chance to keep them before the restriction expires and free competition, comes back in. The second is information. Customers or companies have trade secret proprietary information. It could be everything from their profit margins to, they might have proprietary ways they make their products. They don't want to get patents on it because patents are public and patents expire. But they don't want the employee to take this to a competitor because that could result in unfair competition. So information's the second main reason they want to use these types of agreements. And then one that's a motivation that's important, especially these days, are employee recruitment. Like with the training, a lot of these employees will get substantial training, and then an employee will leave and he or she will solicit her former colleagues at the employer, and the employer, they're like, I know they should be able to get another job, but I just trained all these people and now my competitors got this ready to go workforce and they didn't have to train them at all. And these days, employers are having a hard time finding good people. So that's the third reason that employers like to use restrictions to protect their employees from unfair solicitation or rating. So it's information, relationships, and employees are in my experience, the three main reasons employers want to use restrictive covenants. Not necessarily non-competes, but non-competes, non-solicits, or non-disclosure provisions.
Thank you. And we're going to get more in some subsequent questions into kind of that whole suite of restrictive covenants and how they overlap. I'm particularly excited about that. But what I wanted to do now is kind of take a few questions from audience members that are generally about the enforceability of non-competes. I'm going to try to kind of bundle them together, and then whoever would like to jump in and shed some light on these would be welcome. One question was, in these recent reforms, how are those income thresholds getting determined? I think that's an interesting question. There's a kind of technical question about how non-competes are or are not enforced across state lines. So like for workers who move, that might be easier to answer. And then there was a question that I'll attempt to answer up front about the recent reforms that we've alluded to. So in Minnesota, that'll go into effect next month, and then eventually perhaps in New York State. One of the challenges of kind of talking about non-compete enforcement is there are so many dimensions of it. So when we say that Minnesota is the fourth state to render them broadly unenforceable, we're kind of excluding the reforms that happened in states like Colorado and Illinois just because they didn't categorically make them unenforceable for workers above the income threshold. For new non-competes in Minnesota, there isn't an income threshold. They're just broadly rendered unenforceable. But again, there are lots of different dimensions, and states have been playing with many of them. But I would love to hear your answers on those, on any of those points. So in particular, perhaps, please go ahead.
Well, I was thinking David and Jane might be good on the income thresholds.
I actually don't know that I have particular insight on Illinois. I was not involved in those conversations. My general impression is that this is not a scientific process. And in fact, this is maybe an area where data is and continues to be really relevant and useful. But I think these income thresholds may be more a result of sort of the political process and what's a number that policymakers can get to that seems reasonable. But again, that's an impression.
I was involved a little bit in negotiating for the employers, and that's my take as well. Was politics, but it kind of makes sense. 45 grand for non-solicit. It's kind of just gut level fairness type of decisions.
In Colorado, it was 100%. I was involved in negotiating for workers, and 100% like a political question. I mean, we did tie it. We had the benefit of there being under our wage and hour laws as relevant to questions of whether in certain contexts workers are entitled to overtime. We had the benefit of a highly compensated employee threshold that we could at least look to as a possible standard, as a very rough proxy of bargaining power, right? Which is really, I think, what we were trying to get at in setting the threshold. But yes, I mean, to be blunt, I'm not sure that it is that the precise threshold of $112,000 in 2023 is tied to any sort of rigorous empirical analysis in particular. And I think it's notable, right, that we're seeing a trend in states like Minnesota and then, of course, the FTC to move away from these thresholds, right, which are fundamentally the result of political negotiation. Although a longer conversation about whether they like have a distorting effect on wages for folks who make somewhere right around that threshold, and which I know that there's been some research on, but I think for that reason too, a broader prohibition makes a lot of sense. This is what we were able to accomplish in Colorado.
So that's all certainly fair, and I follow up with another question from the audience. It is about those caps. The questioner is asking, doesn't that limit the income that someone could make? Why would an employer want to give a pay increase past that amount? And I actually think it sort of works the opposite direction. And I know that some economists are looking at whether employers respond to these reforms by boosting workers just over the threshold so that they can have them sign non-competes. And I think that we're still in the early stages of learning whether that's the case. I am curious whether any of the panelists have seen that. In particular, I guess you, Jeff, have you seen employers thinking along those lines, thinking, we need to boost wages in order to have an enforceable non-compete?
For me, they're more concerned about non-solicitation, protecting their relationships, or non-disclosures, protecting their information. And most people make over 45,000. And I haven't seen any problems with the non-compete, with the employees that they want to have subject to a non-compete making 75,000. So I haven't seen that pose a big problem for any employers so far.
Fair enough.
I will say, in my experience, investigating non-competes and negotiating settlements with employers when I was at the Attorney General's office, I think some of these thresholds pause or sort of prompt an employer to evaluate what do different categories of workers do, at what level are they compensated, and what level of protection do I need for the kinds of information and client relationships that group of workers has, right? And so I think prior to some of these reforms, an employer might, and I've certainly seen this, use a single non-compete for essentially all employees in a firm. I think that these types of reforms essentially prompt the employer to say, who do I need this non-compete for? Who do I need a non-solicit for which categories? For whom is a confidentiality agreement going to be enough, right? So it just sort of prompts that more nuanced analysis at different income levels and job duties and exposure to confidential information and all those things.
That makes sense. All right, so I want to turn to something we've alluded to a couple times, and that's the prospect of federal action in this area. So, non-competes have been the subject of congressional proposals for several years now, but those bills have not yet been passed. In 23, we've seen, I think, the first two actions kind of moving towards implementation occurring outside of the legislative process. I'm thinking of the NLRB and the FTC that have both announced some actions against non-competes. And I guess my question for the panel is, what's the chance, both in the nearer term and the longer term, that these actions really do substantially limit non-competes? I think the corollary to that question for those who are kind of concerned at the state level is whether those state actions are, rendered moot by federal actions. And I think the answer to that is no, but I'm curious about your thoughts on that kind of broader question.
Well, the FTC rule would supersede state law. That's the goal. And it would also require rescission of existing agreements, non-compete agreements, and employment and severance agreements. So I do know that if they're going to vote in April 2024 on that rule. And then there'll be constitutional questions about whether it's enforceable. But as drafted, that's their intent, is to supersede state law from the FTC's from the FTC. NLRB is a little different. Their focus is whether it chills workers' rights to collectively bargain or otherwise improve their situation under Section 7 of the NLRB Act. And that's going to be the General Counsel of the NLRB has directed the field offices to forward to her attention potential cases that can be brought. I think they just brought their first one in the state of Michigan a couple of weeks ago. And then she also advises the NLRB itself, which decides, unfair labor practice cases. So they're kind of two different tracks. I'd say the FTC would be the most dramatic if that becomes law, because it supersedes state law. I don't know what the other panelists think. That's how I see it.
I mean, I think that it does supersede state law insofar as agreements that would be permissible under state law will no longer be permissible. I mean, it does preserve state law in lots of various aspects. I mean, I want to highlight in particular on enforcement, right? I mean, this is an area where I think it will be really important for us to see continued state policy making, right? Because, well, the FTC can declare something an unfair method of competition, which it has with respect to non-compete agreements, which may inform enforcement tools available under state law as a general matter. I think specific enforcement mechanisms are absolutely essential, right? Because of the non-compliance that we're so used to seeing. So, for example, Colorado statutory penalties and all of those things will still be in place regardless of what the FTC does with respect to agreements that fall within Colorado's prohibitions. Another area where I think where I am quite interested in seeing how employers respond to the FTC rulemaking is with respect to what we described as de facto non-compete agreements, right? We have seen explicitly in places like California, for example, that employers and employers associations have actually encouraged employers to adopt employer-driven debt, to adopt stay or pay contracts as an alternative to non-competes, right? Because of the suggestion that those agreements don't fall within California's broad prohibition against non-competes, which I disagree with, but that's a position that employers have taken, and I think we would see employers continue to take if the FTC isn't crystal clear on the applicability of its rule to those kinds of de facto non-compete agreements. So I think that there will be a need for continued policymaking at the state level, in particular to provide enforcement tools to clarify whether and when agreements that operate like non-compete agreements, but that may have either fall outside of the FTC rulemaking or have uncertain or to which the FTC rulemaking is not clearly applicable. So that's something that states can and will need to clean up.
That's all really helpful. And I think, oh, please go ahead, Jane.
All I was going to add to what David just said is, and I also think that it would still need to play out how, for example, an FTC rule then applies or a sort of NLRB analysis applies to a sort of fissured, multi-layered workplace, right? Where you have employers with direct hires, staffing agencies, contractors, et cetera. I think those sort of ripples would continue to play out both in state and federal.
And the only thing I'd add to all this, I think this is all sort of under the assumption that over the long run, that the FTC's actions sort of survive judicial challenges. And I think that is a difference, right? That the state actions occurring in a, I'm an economist and not a lawyer, but this is something that I understand has been governed by states for a long time, and where states' authority to act is not, subject to question. So that seems like another wrinkle in kind of the interplay of the federal and state efforts here. Okay, so, actually something that you just talked about, David, I want to get into as we talk about the broader array of restrictive covenants. I want to talk about sort of how all of those fit together, the training repayment agreements, but also non-solicitation, non-disclosure agreements, and so forth. And actually, Jeff, if you don't mind, you had started to kind of delineate those a little earlier in the talk. And I'm wondering if you could kind of get a little deeper into that, and then we could kind of have a broader discussion about, how employers might be using some of these other contracts in response to reform efforts, as they look to find other ways to accomplish their goals. But first, just helping to lay those out would be great.
Yeah, sure. So the four major restrictions, and these are in employment agreements, severance agreements, mainly what we're talking about here. Non-compete, That's, you can't go to a competitor in a geographic area for a certain amount of time. Generally, that's what they provide. That's what we're talking about banning today. To non-solicitation as to customers or employees. So the customers are just to keep the employees in-house, give the employer a chance to keep them in-house. It typically only applies to customers that the employee personally dealt with. You can't ban them from calling on any customer of the company, but if they had personal relationships with the customers, that's the type of relationship usually you try to protect. The third is solicitation of your employees, recruiting them to go join a competitor. And then the fourth are non-disclosure provisions, trade secret, confidential proprietary information that you don't want to use, you don't want them to use or disclose on behalf of a competitor. And the overall concern is that it will result in unfair competition. And that's why this is an interesting area of the law. Generally, contracts are upheld by courts, right? But also generally you're free to compete. So when you get a restrictive covenant on an employee, those two policies conflict and the courts have to sort out, well, does the employee have a legitimate beef here or is it overreaching? And so on the non-competes, what my clients mostly do is they can usually get what they want with a non-solicitation and a non-disclosure provision. For instance, why do you need to ban somebody in many cases for a 50-mile radius from calling on anybody in that business if they only dealt with 20 customers? Why can't you just ban them for 18 months or 2 years from calling on the customers that they had relationships with? That's where you can use a non-solicitation instead of a non-compete. On the other hand, let's say you're like a trading firm, right? You have some proprietary technology, or you're a manufacturing firm that has this special way to make a product. You might not want your employee going to a competitor, period, because you can't monitor whether they disclose it. They could do it verbally, and then 2 years later, the product could show up manufactured the way you manufactured it. And it's very difficult to control that, to enforce it, to prove it. So in some cases, there still are situations where employers are like, I don't want to use non-disclosure. I need a non-compete because I'm not comfortable with them going there under any circumstances.
Jane or
Does that
David?
does that help?
Absolutely. And I just want to hear now, from Jane or David too, about that question of kind of the interplay of these different restrictive covenants, any possible substitution in response to some of these reform efforts. We've already touched on some of this, but any other thoughts you have on this would be of interest.
I think that I think that the question of some of these are like really semantic questions, like what is a non-compete agreement? Like I'm not sure that there's that it matters what the sort of platonic non-compete agreement is. What I'll say is that many states' laws, including California's laws, right, and Colorado law, I think gets it right and says non-compete agreements are covenants that not to compete that those laws are concerned about involve the kinds of things that prevent a worker from going to work elsewhere, right? California law says that it prohibits contracts that restrain people from engaging in a lawful profession. So and in many cases that will reach stay or pay contracts that say you've got to pay a lot of money in order to leave the job, right? I mean, in many cases, in cases that I'm litigating that appear very much like modern day indentured servitude, those are, illegal non-compete agreements or covenants not to compete as well. And I do think that non-solicits and confidentiality agreements, depending on their breadth, can also amount to a covenant not to compete that substantially undermines worker mobility, right? That strips workers of one of the key components of their bargaining power, which is the threat, the ability to leverage the threat of exit, right? Which is really fundamentally what we're talking about here, right? Which is one of the few ways in which workers can get a fair shake. So, Colorado's law, for example, like with respect to non-solicits, says non-solicits are permissible, but only if the worker is paid, more than 60% of the $112,000 threshold, right? And confidentiality agreements have to be tied, specifically to the protection of trade secrets. So I think that the categorization is of limited utility, really. Like the question should be like, does this strip workers of this key component of their bargaining power? And then how do we want to, protect them and clarify how the law applies?
And I would just add that I think, going back to some of those findings from the interviews that were highlighted kind of at the top of this panel, right? The timing issues, the power dynamics issues, the legalese, what does this mean? All of those sort of concerns that workers expressed in their interviews apply, whether the contractual language says non-compete or training agreement or non-solicit, right? Like to a worker, particularly lower wage workers, right? Or those who, have less educational background, right? It's still legalese that is keeping them from moving from a job or perhaps speaking up at work. Obviously, in terms of how the law would enforce it, there may be gradations that matter. But in terms of the power dynamics, I don't know that there are sort of notable differences.
Can I jump in though and just say, I want to make sure I'm understanding what you and David are saying. And as I hear you, you're saying, what we have to do is understand really the economic or the behavioral effects on workers of these different restrictive covenants, and that's kind of the key distinction. So that if there's another restrictive covenant that ultimately leads workers to make the same kinds of adjustments in their behavior, that you'd want to regard those similarly. Because I think at the same time, I had, my prior had been that there are some restrictive covenants that are much more narrowly tailored than a non-compete. So, if there's a non-disclosure that agreement that's really narrowly tailored and that allows you to, take other jobs, it's not functioning effectively as a non-compete. And so kind of the devil's in the details of what the covenant is and what effects it has. I'm curious if you kind of accept that characterization.
I think perhaps we're saying the same thing, just perhaps in reverse, right? That there can be there are forms of restrictions that are much narrower and have much less of an impact. However, just because something is called a non-solicit, the devil is in the details, or training repayment, does not mean, or even a confidentiality agreement, does not mean that it may, in the details, have essentially an identical impact as a non-compete, right? So you really have to look at what it says, the substance, the effect, as opposed to the sort of contractual or legal term that's used in the contract. I don't know if you would characterize it that way, Dave.
100%.
If I could I would just say though, when you're talking non-compete versus non-solicit, if you're the worker, I'd much rather, if faced with I can't work within 50 miles in the industry period versus I can go to work at the competitor across the street. I just have to stay away from my accounts for 18 months. That's a big difference. I think that's
Totally
better. And you're right. It depends on the language though. Like if it's any company our customer ever dealt with, that could include everybody in the 50-mile radius. That probably wouldn't be enforced, certainly under Illinois law, but you're right. You got to look at the language, which is one reason I'm not a big fan of the statutes. I think letting the courts look at them and consider all the factors for sophisticated employees, at least, I think gets better results. I agree though, a cosmetologist or, who knows if they understand it or if they have the willingness to contest it if it's unfair. So that's why, I understand the income thresholds. That's a valid concern in my opinion.
Here, I would put in a plug for the work by some economists who are starting to try to understand restrictive covenants other than non-competes. And this is a really early stage, literature, but Aaron Sojourner, Evan Starr, their co-authors on a couple papers have been trying to understand kind of how these all work. And I think that would be helpful for this conversation, which actually leads me to a question I wanted to ask you all, which was, given what you're hearing from researchers from some of these initial data sets that have started to include information about non-competes, like what would be useful to you, to the folks you work with, to the policymakers you've had discussions with? What else would you like to know? And I think that that's something that would be of interest to the researchers in the audience, and certainly to me, to just understand, where folks on the analytical side should be making investments of their time?
Thanks, Ryan. Just a couple that stand out to me, and it's something that and I think that there's to name a few, certainly not a sort of comprehensive list. And I want to commend some of the research that we discussed earlier as sort of, I think, doing some of the work that I'll suggest I think needs to be done more. I mean, the first is not to get, as Jane and I just sort of discussed, right? Not to get sort of sucked into the traditional legal frameworks, developed by lawyers and judges, and thinking about what are non-competes and how they operate, right? Because I think that very often doesn't align with the experiences of workers and with the labor market consequences of restraints on worker mobility, contractual restraints that undermine workers' ability to go and work somewhere else or threaten to work somewhere else in order to get a better deal. The other thing that I want to highlight that is, I think, exceptionally hard to study, right, is that we see, but except through qualitative research, which I think is, as we discussed earlier, can be really effective, is that we see lots of distorting effects on wages, but the consequences of restraints on worker mobility extend much further beyond that, right? So, one of the first, a case that I worked on involving no hire and no poach agreements in the franchise fast food context several years ago, our clients would describe how not only did they feel like their bargaining power was undermined to get a fair shake with respect to wages, but they were stuck in jobs where they didn't have fair schedules, right? Where they couldn't go to their kids' parent-teacher conference, right? And in fact, those were the things that really stood out to them as being the harms of the restraint, right? That more likely to be subject to hostility and bad employment practices. And I think that it would be great to see more research in that context.
To that point, right, Orly Lobel certainly sort of her research raises some questions around, do non-competes have a disproportionate effect on women, for example, because women are more likely to be caregivers, to be geographically constrained because they have to, have childcare obligations or elder care obligations. And so then is there some greater impact on those regional restrictions, which I was also thinking about the caregiver question in hearing about the age groups, who's likely to be subject to a non-compete, right? Workers who are exactly also in the age demographic in which they're likely to be both caring for children and caring for elders, right? So I think, yeah, that's very interesting. Like, how does a non-compete beyond earnings interplay with sort of other ways that workers have to make decisions about work given the other things in their lives?
Makes sense. And it reminds me of some work by Matt Marks looking at women entrepreneurs and how they're affected by non-competes. And as I recall, he finds somewhat larger effects on their entrepreneurship activity. It's something we haven't talked a whole lot about in this conversation, but it's just a whole nother arena for research and for kind of thinking about the effects of the policies. I do want to turn to an audience question specifically for you, Jeff, about whether you see non-competes with industry-wide scope, sort of without respect to geography. Is that something you ever encounter?
Sure. Yeah, you can. Yeah. So generally, the classic non-competes geographic, but yeah, you can have it nationwide in the industry, and with the way work's going now, there's people that service customers all over the country, and that could make sense in the right setting to have an industry-wide non-compete. Now, here's the thing, though. I mean, to prove that, what are you protecting when you're banning them from the whole industry? Like, what is it? Is it the relationships? Because usually they only have relationships with a certain client set that they personally service. So I think that's that's a tough one for the employer to prove they have a really legitimate interest to support that. But yeah, you have industry-wide non-competes for sure. Mm-hmm.
Thank you. There's another question about enforcement. Are there typically so this is getting to kind of questions about workers who are laid off. So workers fired without cause. And I know that in some states that non-competes are categorically unenforceable in that situation. In some states, they are in principle enforceable. But I think the question is, both whether there's been any legislative attention paid to this dimension of enforceability, and also, I guess, whether this is something that actually is in practice something that ever gets litigated. I think those are two distinct questions.
So the Illinois amendments did address this question specifically. And I think largely in the context of the COVID-19 pandemic and sort of mass economics and pandemic-driven layoffs, right, said that a covenant not to compete isn't enforceable. Here it is, as a result of business circumstances or governmental orders related to the COVID-19 pandemic or circumstances similar. So I think it's an interesting aspect of the Illinois law, clearly very much on the mind of policymakers at the time that these reforms were passing.
I could say Colorado law just doesn't distinguish, right? And doesn't vary depending on how a worker's employment may have terminated. But certainly something that is litigated and does come up. And I mean, I can say we see lots of covenants, right, that purport to apply regardless of how the employment ends, right? So including in the training repayment agreement context, like pay us back for the cost of training, no matter how your job ends, whether you leave or even if we fire you, right? So it's certainly something that comes up.
Just so you know, like, why would you want to enforce a non-compete to somebody that you fire, right? Well, what if there's malfeasance involved, right? And you fire them. Why shouldn't you be able to enforce their non-compete if you can, or their non-solicit if it's otherwise legitimate, right? If you're going to reward them for getting fired, that's kind of why you got to, each case really needs to be evaluated on its own merits. And really quickly on the research, I'd like to see, don't forget the employer side of it. Like if non-solicits are banned, are employers how's that going to affect compensation of sales representatives, right? If restrictive covenants are banned in a state, how's that going to impact where employers want to locate? There's two sides to the equation. So, don't forget the employers.
Absolutely. And I think that in that area, the data are even less well developed than they have become on the worker side, but that I hope that as we continue to get more information, we can do things like understand, the different implications that restrictive covenants have for sort of established incumbent businesses and new businesses. I think that there are quite different dynamics at play for those, and as you say, a lot to learn there. We are just about out of time, but I want to ask a final question about advice for policymakers that each of you might have, kind of arising from just the sum total of your participation in these discussions, your experiences with state level reforms. If you were advising either a federal policymaker or just a state policymaker who's contemplating action on non-competes, is there anything you think is underappreciated or that you'd like to kind of inject into that conversation? And that's, I realize, a very broad question to fire at you right at the end of a panel.
I mean, I think that this is true in lots of contexts, not just with respect to these types of regulations, but is to not forget about enforcement, right? I mean, I think it's sometimes policymakers will lose track of, or it's easy to assume that the words on the page, right, will on their own change behavior, and we far too often see that that's not the case. So to make sure that enforcement is a key component of the reform.
Well, thank you. Any final words from you, Jane or Jeff? And if not, I just want to, please go ahead.
Ladies first.
Well, I was going to yield to Jeff if he had any.
What I just say to policymakers is, these have been enforced for centuries, and they can definitely be abused. And I've seen it in my own practice. And I get the income thresholds and the attorney review enforcement, but just don't forget, there's very important reasons for them as well. And if they're reasonably tailored and there's a real legitimate interest, we don't want to throw the baby out with the bathwater. That'll be bad for everybody. And there's a century of case law on this with smart judges with lots of information hammering out rules on it, and you know, they think sometimes they're enforceable and sometimes they're not. So just keep it in mind, you know, there's interest on both sides.
Yeah, and I guess my final thought then, piggybacking on that, is this has to last, right? I mean, in my current job, I enforce many laws that were passed, right, essentially are built on like a 1939 framework, right? So these laws exist for a long time, and yet employment relationships and workplaces continue to evolve. And so I think thinking more broadly about what's a framework that's reasonable, but allows room for dynamics and workplaces and sort of contracts to continue to grow and change, because they will.
Great. Thank you. And really thanks to all of our panelists. I think this has been a fascinating discussion. I know I've learned a lot from it. Thanks to everybody who's tuned in, for your questions, for listening, and have a great rest of your day.